Get that girl out of my courtroom before I have her arrested." He didn't lower his voice when he said it. That was the thing. Judge Raymond Coulter said it the way you'd say close the window or pass the salt. No hesitation, no performance. Just a man accustomed to being obeyed before the sentence was finished. The girl he was talking about was 23 years old. Her name was Petra. Wait, no, that's not her name. Her name was Avery Nkosi, and she was standing at the defendant's table in a courtroom in Harlan County, Kentucky, wearing a blazer she'd borrowed from her neighbor, Mrs. Tillotson, because her own had a rip along the left shoulder from the last deployment, and she hadn't gotten around to replacing it yet. She was 5'6". She held a manila folder. Her hands were not shaking. The lawyer across the aisle, a man named Clifton Ware who'd been practicing for 31 years and had the cufflinks to prove it, he laughed, not loudly. Just enough. Avery didn't move. And here's what I want you to understand before I tell you anything else. Avery Nkosi had, at various points in her life, disarmed a man twice her size in a gas station in Fallujah, navigated a broken APC through a checkpoint in the dark, and carried a wounded team member for 400 meters through a riverbed while bleeding from her left side. She was not, by any measure, a woman who scared easily. But that courtroom scared her, not because of Coulter, not because of Ware. Because sitting behind her, in the third row on the left, was her mother, Josephine Nkosi, 61 years old. The kind of woman who ironed her church clothes on Saturday night and kept a savings account she called the Dignity Fund because she said a black woman always needed to have enough money to walk away from something without asking permission. And Josephine was about to lose the only thing she'd never had to walk away from. The house on Breckenridge Road had been in the family for 52 years. Josephine's parents had bought it in 1973, which meant they'd bought it during a time when banks in Harlan County were still finding creative ways to say no to black families, which meant they'd scraped and borrowed and shown up to a closing with a certified check and a lawyer friend who'd driven 4 hours from Louisville just to make sure the title transferred clean. That house meant something. It wasn't just walls and a roof. It was evidence. Evidence that they had been here, that they had built something, that it was theirs. Now, a development company called Meridian Landworks was claiming that the back portion of the property, a strip of land running along the fence line, about 18 feet wide and 200 feet long, belonged to them, had always belonged to them, that the original survey from 1973 had been misread, that the deed contained an error, and that the Nkosi family had been, for 5 decades, unknowingly occupying land that was not theirs. Meridian's lawyer was Clifton Ware. Josephine had hired a lawyer named Gerald Hines. Gerald Hines had reviewed the case for 3 weeks, and then called Josephine to tell her that the original deed was, in fact, ambiguous, that the survey markers were old and possibly displaced, and that Meridian had the resources for a long fight. He recommended settling. Josephine told him she would think about it. She thought about it for one night, and then told Gerald Hines she would not be settling. Gerald Hines withdrew from the case 2 days later. The second lawyer, a woman named Barbara Chu, who specialized in property disputes, took the case for 6 weeks before her firm decided it had a conflict of interest. She withdrew. The third lawyer never returned Josephine's calls after the second meeting. That was when Josephine called Avery. Avery had been out of the Army for 14 months. She'd done 2 tours, the first with the 82nd Airborne, the second attached to a special operations unit she was not permitted to discuss in specific terms. She was living in a rented room in Lexington, taking college classes she hadn't decided whether to finish, working weekend shifts at a logistics warehouse to cover the rent. She was not a lawyer. She had never been a lawyer. She had, however, spent 14 months being slowly suffocated by the particular silence of a life that no longer had a mission, and when her mother called, she got in the car. She drove down on a Thursday. Josephine made chicken and rice and didn't say a word about the case until the dishes were done. Then she spread everything out on the kitchen table. The original deed, the survey plat, the letters from Meridian, the correspondence with all three lawyers, and a stack of county records. She'd pulled herself from the clerk's office because she didn't trust anyone else to pull them right. Avery looked at everything for a long time. Then she said, "Who moved the markers?" Josephine looked up. "The survey markers," Avery said. "The county records show where they were placed in 1973. But Meridian's survey, the one they're using now, it shows different positions. So either the original surveyor was wrong or something moved." Josephine was quiet for a moment. Then she said, "Roy Pickett used to do the groundskeeping for the Hendersons. He told me once that he'd seen men out near the fence line. Maybe 3-4 years ago. He thought they were utility workers." Avery wrote that down. She spent the next 6 weeks in the Harlan County Clerk's office, in the public library, in the parking lot of a title company in Middlesboro, where she sat in her car for 2 hours waiting for a records clerk named. She'll never forget this. Sheila, just Sheila, no last name given, who finally came out on her lunch break and confirmed that yes, the original 1973 survey plat was on file, and yes, it had been scanned into the digital system in 2019, and yes, the scan was available to the public, and no, Sheila didn't understand why Meridian's lawyer kept saying the original was unavailable. So that was one thing. The second thing was the markers themselves. Avery is not a surveyor, but she had trained at various points in land navigation, in reading topographical maps, in understanding how fixed reference points work and what happens when they shift. She borrowed a measuring tape, a long one, from Mrs. Tillotson's garage. She walked the property line. She compared what she measured to what the 1973 plat showed, 18 feet. That's how far off the current markers were from where they should have been. Not inches, not a foot, 18 feet. Now here's the part where I want to stop and ask you something directly, because I think about this a lot. Avery Nkosi is 23 years old. She has no law degree. She has no paralegal certification. She has a borrowed blazer and a manila folder and a mother who ironed her church clothes on Saturday night. The court date is in 3 weeks. Every lawyer who looked at this case walked away. The judge assigned to the case, Judge Reid Coulter, has ruled in favor of Meridian Landworks in 4 of the last 6 property disputes that came before his court, all involving black landowners on the south side of the county, all decided in the last 8 years. What do you do? Do you keep looking for another lawyer? Do you file for a continuance and hope something changes? Do you let Meridian take the land and tell yourself at least you still have the house, at least you still have the part that matters? Or do you walk in? Avery filed a motion to appear as a non-attorney legal advocate on behalf of her mother. In Kentucky, this is permitted in certain civil matters under specific conditions. She researched the conditions. She met them. She filed the paperwork herself, using forms she found on the court's own website, forms that had been sitting there the whole time, available to anyone who knew to look. Clifton Ware filed an objection. Judge Coulter overruled it. Technically, legally, he had to. But he did it in a way that let everyone in the room understand how he felt about it. And then it was the morning of the hearing, and Avery was standing at the defendant's table in Mrs. Tillotson's blazer, and Coulter was telling someone to get that girl out of his courtroom, and Clifton Ware was laughing his quiet laugh, and Josephine was sitting in the 3rd row, holding the straps of her purse with both hands. Avery looked at the judge. She said, "Your Honor, I'm here pursuant to KRS 454.005. My presence has already been approved by this court. I'd like to proceed." Coulter looked at her the way you look at something you've decided is beneath your attention. Then he said, "Fine, let's get this over with." Clifton Ware's opening was smooth. It always was. He talked about the survey. He talked about the original deed's ambiguities. He talked about Meridian's investment in the region, their development projects, the jobs they'd created, the tax revenue. He had a display board. It had charts. He was very good. When he finished, Avery stood up. She did not have a display board. She had the manila folder and a legal pad and the copy of the 1973 plat that Sheila had helped her access. She placed them on the table in a specific order, the way she'd been trained to organize equipment before an operation. Everything in its place. Nothing wasted. She called Meridian's lead surveyor as her first witness. His name was Douglas, the kind of man who had a belt that matched his shoes and answered every question with slightly more confidence than the question warranted. He confirmed the survey. He confirmed the current marker positions. He confirmed the methodology. Then Avery asked him, "When you placed the current markers, did you reference the original 1973 survey plat filed with the Harlan County Clerk's office?" He said yes. She said, "And the plat you referenced, where did you obtain it?" He said, "Meridian's legal team had provided it." She said, "So you did not retrieve it directly from the county clerk's records?" He said, "No, he had not." She said, "I'm going to show you two documents. The first is the survey plat provided to you by Meridian's legal team. The second is the original 1973 plat as scanned and filed with the Harlan County Clerk's office in 2019. I'd like you to look at the parcel boundary markers on both documents and tell me if you notice any differences." Coulter leaned forward slightly. Ware's pen stopped moving. The surveyor looked at both documents for a long time. He said, "The reference coordinates on the northeast corner are different." Avery said, "By how much?" He worked it out slowly, visibly, the way people do when they're calculating something they wish they didn't have to calculate. Then he said, "Approximately 18 feet." The room was very quiet. Avery said, "So if you had used the original county-filed plat, the one recorded in 1973 when the Nkosi family purchased this property, rather than the version provided by Meridian's legal team, where would the boundary markers fall?" He told her. They would fall 18 feet inside what Meridian was currently claiming as their land. Avery let that sit for a moment. Then she said, "No further questions." She called one more witness. His name was Boyd Calloway, and he was a retired county engineer who had worked in Harlan County for 26 years and who, it turned out, had been present at the original 1973 survey as a junior county official. He was 78 years old, and he drove himself to the courthouse in a truck that had a hand-painted stripe along the side, and he sat in the witness box like a man who had been waiting a long time for someone to ask him the right question. Avery asked him where the original markers had been placed. He told her. She asked him if the current markers matched that placement. He said no. He said he'd driven by that property 3 years ago and noticed the fence line looked wrong, but nobody had asked him about it, so he hadn't said anything. She asked him, "Mr. Calloway, in your experience, can survey markers shift position on their own over 50 years?" He said, "Not 18 feet, they can't." Clifton Ware objected. Sustained. The answer was stricken. But everyone in that room had heard it. Avery looked down at her legal pad. She had one more question. She'd written it down, crossed it out, rewritten it 4 times over the past 3 weeks. She'd rehearsed it standing in the kitchen while her mother pretended to watch television in the other room. She'd said it out loud in the parking lot of the county clerk's office while Sheila watched from the doorway with a coffee cup. She looked at Ware. She said, "Mr. Ware, I have a question for you." He looked surprised. Lawyers don't usually question each other directly in civil hearings. But Avery had done her research, and there was a procedural avenue, and she'd filed the right paperwork 3 weeks ago, and Coulter, who was not happy, who had not been happy for the last 2 hours, but who was also a judge who understood what a reversal on appeal would mean for his record, allowed it. She said, "Meridian Landworks filed the first survey in this dispute in March of last year. At that time, you represented to this court that the original 1973 plat was unavailable, quote, not retrievable from county records, unquote. Is that correct?" Ware said that was his understanding at the time. Avery said, "I'm going to show you a document. This is an email from the Harlan County Clerk's office, sent to your firm's paralegal on February 14th of last year, 6 weeks before you represented to this court that the document was unavailable. The email contains a link to the digitized 1973 plat that has been available on the county's public records portal since 2019. Would you like to review it?" Ware did not answer immediately. Coulter said, "Mr. Ware." Ware said he would need time to review the document. Avery said, "Of course. I have copies for the court." There is a version of this story where what happened next was dramatic, where Coulter slammed a gavel, where Ware made a scene, where the gallery gasped. That's not what happened. What happened was quieter than that, and somehow worse for Meridian because of it. Coulter reviewed the email. He reviewed the two plat documents. He called a 20-minute recess. When he came back, his face had the particular stillness of a man doing very careful arithmetic in his head. He ruled in favor of Josephine Nkosi. The strip of land along Breckenridge Road, 18 feet wide, 200 feet long, 52 years of belonging to someone it was always supposed to belong to, stayed. The original boundary markers were to be restored to their 1973 positions at Meridian's expense. Ware's representation regarding the availability of the original plat was referred to the State Bar's Review Board. That last part Avery had not expected. She'd asked for the land. She hadn't asked for anything else. But Coulter, it turned out, was not entirely without a conscience. He was a man who liked winning, and the math of what had happened in his courtroom that morning was not math he wanted to be associated with on appeal. Avery walked out of the courthouse into the afternoon light, and Josephine was right behind her. And for a moment, neither of them said anything. The parking lot smelled like cut grass and diesel from a truck idling at the far end. A bird was doing something persistent in a tree near the entrance. Ordinary things, the kind of ordinary that feels almost loud after you've been holding your breath for 2 hours. Josephine put her hand on Avery's arm. Not a hug, just a hand, firm and warm, the way this woman had always communicated the things she considered too important for words. She said, "Your grandmother would have liked that." Avery thought about the savings account, the dignity fund, the certified check in 1973, the lawyer who drove 4 hours from Louisville to make sure the title transferred clean, the whole long chain of people who'd held something and refused to let it go so that there would be something to hold. She said, she kind of was there. The State Bar Review of Clifton Ware's conduct concluded 11 months later. His license was suspended for 90 days. Meridian Landworks faced a separate civil investigation into their surveying practices across the county. Boyd Calloway gave a statement to the county commission. A local paper ran a short piece. Nobody called it a landmark case. Nobody made a speech. The fence on Breckenridge Road got a new post that fall, set in concrete, in exactly the position it was always supposed to be. Avery went back to Lexington. She finished her degree. She started law school the following year. She still has the legal pad, the one with the question written 4 times and crossed out 3. She keeps it in the drawer or next to her bed, under a copy of the Kentucky Rules of Civil Procedure and a photograph of a house with a fence in the right place. Some things, once they're yours, you don't let go of twice.